Hey everyone, attorney Robert Byrne here. Thanks so much for visiting my channel. I'm a little late to the party in chiming in on Amber Heard's motion to set aside the verdict. I do have some thoughts on it that I want to share with you, some kind of big thoughts, and I also want to show you some Virginia law that really, I think, is going to deal with much of what she's raised here. I also want to deal with this potential fake juror argument, so stay tuned. Before I get into the meat of the matter, I do want to discuss a couple of overarching principles that a court's going to look at when it's reviewing a motion like this. Number one, parties that lose trials will very typically file a motion to set aside a verdict. And one of the reasons that they do so is not necessarily because they actually believe they're going to win the motion, but it's because they want to make sure that it's abundantly clear that the trial court has had an opportunity to rule on the various issues. So they're trying to make sure that they're preserving issues for appeal, preserving errors for appeal. A second thing to consider about this particular motion: Virginia law is very clear that a party that is armed with a favorable jury verdict is in one of the best and most favorable positions in the law. The jury has decided all of the facts in their favor, or at least the critical and material ones necessary for them to win. And they're in this position where the appellate court's job is to find out if there's any evidence that supports the verdict that was reached. So arguments that say that there's not enough evidence, which often are called insufficiency of the evidence arguments, or arguments that say, well, there was conflicting evidence that was believable and credible that the jury disregarded, those arguments really don't stand a chance on appeal. Virginia appellate courts are going to bend over backwards to try to uphold a jury verdict. Now, there is an exception, and that is if the judge has made an error of law. And so I want to take a look at these arguments that are listed in the brief that Heard's team filed and see what arguments might have merit based on what has been presented. So let's take a look at what the brief actually says. So when we turn to the table of contents, you can see in the argument section that the first set of arguments talk about how the damages awarded by the jury are unsupported by the evidence and the law. Right there, without reading anything else, this argument comes across as a loser when you say the evidence doesn't support the jury's finding. Because what you're talking about then is really what's called an insufficiency of the evidence type argument. And having clerked for the Court of Appeals of Virginia, which is the exact court where this case is now headed, I can say that I have never seen a sufficiency of the evidence argument work on appeal. And I saw hundreds and hundreds of cases. And I bet probably hundreds of those cases actually alleged sufficiency of the evidence. So if we take a look at the actual arguments that are being made here, you can see there's no evidence of pecuniary damages from the op-ed. The jury's compensatory and punitive damages awards were excessive as a matter of law. That Mr. Depp's not entitled to damages for any conduct prior to the op-ed. Mr. Depp's not entitled to damages for alternative causes. The Virginia case law supports setting aside damages judgments that are excessive. Really, when you boil each of these arguments down, I would contend that every single one of them is a sufficiency of the evidence argument. And basically what Heard's team is doing is they're saying Depp did not put on evidence to support the findings that the jury actually reached. So check this out. A lot of defamation law that exists is law that was handed down by the federal courts, particularly the Supreme Court of the United States. Well, Virginia has its own body of law that's built upon First Amendment precedent that deals with defamation law. In the seminal case in Virginia jurisprudence dealing with defamation law is Gazette Incorporated versus Harris. In the Gazette Incorporated versus Harris case, the court was dealing on appeal with some of the issues that we're dealing with here, which is the verdict was excessive. There was insufficient evidence to support the jury's verdict. Those types of issues. And what's interesting is the court dealt with these by saying that the newspaper now contends there was no competent evidence to support the plaintiff's alleged emotional injuries, asserting the plaintiffs offered only vague generalizations and conclusory self-serving opinions. And these statements of opinion or conclusion, utterly lacking a factual basis, cannot meet the standards of competent evidence of actual injury. And there, the court says this is an argument that the evidence was insufficient to support a finding that the plaintiff suffered mental distress. It's not a true excessiveness argument. So they're saying, listen, what you're trying to say is you're putting a different spin on the evidence that came out, and you're saying we disagree with how the jury weighed that evidence. But that's not an excessiveness argument. That's dealing with the sufficiency of the evidence. I think it's fair to say that several of the defendant's arguments in the Depp v. Heard case in this motion to set aside are along those same lines. Really, they're just challenging the sufficiency of the evidence. They're challenging how the jury weighed it. And those arguments lose every single time. The motion dealing with these first sets of arguments also takes issue with the fact that Johnny Depp could only claim damages from the time of the op-ed up until November 2nd, 2020. And they say that that was the period in which he was limited to claim damages in this defamation action. He could not claim anything beforehand. He could not claim anything afterwards. That period of time sandwiched between two events, which were the date of the op-ed and the date of the judgment from the United Kingdom. So Heard's team is saying, hey, Depp promised the court that he was going to not claim anything from before the op-ed or anything after the UK judgment. But Judge, he came into the court and in his closing argument and in elsewhere, he claimed damages going all the way back to 2016, which is when Amber Heard got the temporary restraining order based on the abuse allegations that then appeared in People magazine. Here's the problem with this argument. The defense is trying to say, Judge, he made a promise, he did not keep his promise. But that's not how litigation works. The way litigation works is it is the duty of the party that is trying to limit evidence to take steps to actively limit it. And so there's different ways that you can do it. You could get, for instance, a stipulation that's in writing where the party actually says, we are not going to claim anything before this date or after this date. It's only going to be within here. And then anytime there was something that was arguably outside of those parameters, there would be an objection. Second of all, it's critically important to understand that to have a successful appeal, you're not pointing out what your opponent did wrong. You have to point out what the judge did wrong. And merely saying that your opponent did something wrong will not get you anywhere unless you objected at the time, brought it to the court's attention, asked the court to give a ruling, and the court gave the wrong ruling. And what's interesting here is that throughout this particular argument, Heard's team keeps pointing to the closing argument and elsewhere and saying Depp's team violated its promise that it made to the court by asking for stuff outside of this particular window of time. But they don't say that the court did anything wrong. They don't say, court, this was unfair because we asked you to fix it and you didn't do it. You didn't do anything about it. But as you look through this brief, you don't see where Heard's team is saying, Judge, you messed up by allowing this to happen. Rather, the argument is, Judge, this was unfair to us because Depp's team did not keep its promise. That argument's not going to go anywhere because that argument was waived by a failure to object. In these first set of arguments, the defense also takes aim at Johnny Depp's damages. And they say, hey, Judge, listen, there's no evidence whatsoever that he suffered $10 million worth of damages. The defense really focuses their efforts on Pirates of the Caribbean 6. They say, listen, there's no evidence that Johnny Depp lost that opportunity as a result of anything that Amber Heard did. Really what it comes down to, that's something that we call a red herring. Because Pirate 6 was not the only item of damages that Johnny was claiming. He was claiming reputational damages. The jury could potentially find that he had other damages as well. In fact, if you take a look at the jury instruction that was given to the jury, you can see that the jury could consider a variety of damages that were beyond and apart just Pirate 6. There's all of these other elements. And let's assume for the sake of argument that the Pirate 6 evidence was completely and wholly inadequate to support the jury's verdict. There's still all these other items for which the jury could have awarded their damages. And one way to think about it is this. Anytime someone suffers compensatory damages at the hands of someone else, there's two separate subsets of compensatory damages. There are what are called economic damages, which can be lost wages, lost business opportunities, lost profits, those types of dollar and cents damages that you can actually track with an accountant. But there's also what are called non-economic damages. And typically in a personal injury action, you're going to be looking at pain and suffering, inconvenience, embarrassment, humiliation. Those are those pain and suffering damages that you don't have an invoice for, that it's really hard to put a dollar amount on, but the law recognizes that those are recoverable damages to the exact same extent that economic damages are. I think Heard's team is focusing so heavily on the economic damages component of this that they're missing the fact that there were non-economic damages as well. And the law is going to recognize that the jury was completely entitled to award $10 million in non-economic damages. Moving along, we can see when we get to page 10 of the brief that Heard's taking aim with the fact that Johnny Depp is not entitled to damages that occurred prior to the op-ed. Heard's team really points out and spends a great deal of time showing all of the negative headlines that Johnny Depp was dealing with before the op-ed was written. And they list them out. You know, you have apparently drunk Johnny Depp cut off at Hollywood Films award ceremony. Johnny Depp has a clear and epic sense of entitlement, ex-managers say. Johnny Depp allegedly showed up drunk to movie premiere, reports say. The real reason Johnny Depp used an earpiece on a film set. And so you have all of these different things that are talking about, say, drug use, alcohol use, some slipping abilities, if you will, that are being attributed to these supposed Hollywood insiders. Heard's team is saying, hey, listen, that's the true cause of why he suffered and why things have dropped off for him. It has nothing to do whatsoever with the op-ed. The problem with this argument is that it's not viewing the evidence in the light most favorable to Johnny Depp, as it should. When you look at the evidence in the light most favorable to Johnny, you see that something very significant and material is being left out. None of those headlines said anything about sexual abuse. And that was something that was of a completely different kind and degree than anything that was really being mentioned before that time. But it's important to remember the cultural moment in which the op-ed came out during the Me Too movement, when you had these Hollywood titans like Harvey Weinstein, who are being taken down by these allegations of sexual assault and sexual misconduct. And so when you take the allegations against Harvey Weinstein and some of these other folks and you juxtapose Johnny Depp and he enters that same conversation, you can see that the drinking and the drugs and the showing up late and the fighting with the ex-managers and all of these things really are somewhat irrelevant, because at that time, at that moment, an allegation of sexual abuse was as devastating an allegation that anyone, anywhere, but especially in the Hollywood industry, could face. And it was something that was absolutely crippling to Johnny Depp. It's something that the defendant's motion here fails to recognize, and it's something that I don't know that the defense was really able to deal with at the trial. But in any event, the 2018 op-ed headline was of such an order of magnitude greater in many respects because of the sexual assault allegation. It brought in something that was altogether new, that had not been alleged before, and it was a game changer of sorts. And I think that's why this argument in particular is going to lose on appeal. Moving on, a lot of times in litigation, one of the things that a defense attorney and a defense team will try to do is to muddy the water, create confusion. Just really, they don't have the burden of proof. They don't actually have to convince the jury necessarily of anything. They just need to make it so that it's confusing, so that the jury can't really follow and decide what the plaintiff wants and what the plaintiff is requesting. And I think the defense tried to do that, to say, hey, listen, Johnny Depp can't blame the op-ed on all of these harms because he had all of this other drama going on in his life. There were all these other things that were happening, and he can't isolate and single out this one cause as the thing that messed up everything else in his life when everything else was going wrong. Well, there's a kernel of truth to that, but the problem is the jury's allowed to make that determination. The jury's allowed to look at all of these things and say, yes, we see that his life had some very unsavory aspects to it. We see that there were some things that were really terrible that happened, but a lot of those things have been going on for years and they didn't really impact him. This was something that impacted him in a completely new and different way. So to make the argument that there were all these other potential causes that Depp did not deal with misses the point, because the jury and the jury alone gets to decide whether he's done that. They did that here, so this argument's going to lose. In its last set of arguments, Heard's team says, Judge, when you're looking at defamation verdicts, the law says you're allowed to look at other defamation verdicts to determine whether this is excessive. And granted, if you look at it that way and you say, well, look, there was $1 million verdict and that one was reduced, and here was a $500,000 verdict and that one was reduced, and then suddenly you have this statistical anomaly of a $10 million verdict, then there is a superficial appeal to that argument to say, this is a completely different animal than other defamation verdicts in Virginia. What's important to understand, of course, is this. This case involved vastly different situations than all of those other cases that are cited in this brief. And really because you're dealing with a Hollywood megastar who is making $50 to $60 to more $1 million per year. And so this isn't someone who makes, say, $50,000 and then is accused of somehow or another committing some sort of a crime, and they're able to continue on with their $50,000 a year job. They do have some embarrassment or something like that. For them, $1 million verdict might be a massive deal. For Johnny Depp, $10 million may not even really move the needle that much. And it's important to have that understanding when you're looking at the magnitude of this particular verdict compared to other verdicts. And so I think comparing this verdict to other verdicts in Virginia is comparing apples and oranges. I think the Court of Appeals is going to recognize that. I don't think there's a basis to argue that this particular verdict is excessive. When we get to page 20 of the memorandum, we can see that Heard's team is arguing that Depp's verdict must be thrown out because it's inconsistent with the verdict that was reached in the counterclaim. This argument's not going to go anywhere because basically what the court's job is to do is to really look at all the evidence that is favorable to Johnny Depp and his verdict and all the evidence that is favorable to Amber Heard and her verdict. The court has to find a way to reconcile them if they can. Well, how can they be reconciled? Pretty simply to say Amber Heard did commit defamation against Johnny Depp with these 3 statements that she made. And that was something that caused harm to him. At the same time, the appellate court can say, well, if we look at what was said against Amber Heard, even though the jury determined that she was engaged in a hoax, she didn't do it on this particular occasion. Or even though the jury determined that she was fabricating evidence, it didn't happen like Adam Waldman said. And so those are how the results can be consistent with one another. So this argument, although they're apparently inconsistent, the court needs to find a way to have them that they're faithful with the evidence, and that's something that it can pretty easily do. I want to next deal with some of the arguments that Heard raised that deal with some nuances of defamation law, because I think that these may be Amber Heard's strongest arguments. Now, that's not to say that I think she's going to win, but I do think that these arguments have a much greater chance than the sufficiency arguments, which are destined to fail. So under this first argument, Heard's team is claiming that the First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve a public figure or matters of public concern. And Heard's team is claiming that when you're dealing with defamation by implication, it doesn't apply when you're talking about public figures. So someone like Johnny Depp. It would apply when you're talking about Mr. Smith down the street, who's a public guy who just keeps to himself, but it's not going to apply to a public figure like Johnny Depp. Here, there's not robust Virginia law on this particular topic, so Heard is looking to other jurisdictions, and she cites a bunch of them. And I think that these arguments have 2 problems. And the first is that Heard is very insistent to say that if the statements in question are true, then even if there is innuendo that is defamatory, it would not apply to a public figure. So for instance, one of the cases that is cited is DeFalco versus Anderson, where Heard's team says that there is no libel by innuendo of a public figure where the challenged communication is true. Here's the problem with this particular argument. First, the innuendo that was contained in the statements was who Heard was talking about. The innuendo and the implication didn't name Johnny Depp by name. Instead, it suggested at most who he was. This is what Heard's team is arguing. Therefore, that implication or that innuendo is not sufficient to support a claim for defamation because he's a public figure. The problem is the innuendo or the implication of who is the subject of the defamation is much different than cases where the innuendo is about the defamatory conduct. So in other words, if the statement was, Pastor Smith loves to spend his Friday nights on East Main Street, that could have a defamatory implication if East Main Street is kind of a lowbrow area of town where there's lots of drugs and seedy activities and different things like that. That's the sort of thing where the statement on its face has an implication that it carries with it that a pastor is engaged in all of this unseemly conduct. So really, in a nutshell, the implication that Heard's team is talking about is the implication of identity as to who the content is about. It's not an implication of conduct or action, which would be an altogether different scenario in which I believe most of the cases are dealing with. But the second problem with this argument is this. Heard is insisting that the statements that she made were true, and there can't be defamation by implication when the statements are true. The problem is the jury rejected that. The jury said these statements are not true. And so that, again, moves it out of that particular safe zone that she could rely upon, because you're not dealing with true statements about a public figure that happen to have implications of defamation. Despite that, Heard argues that Mr. Depp did not present evidence that the statements at issue were untrue on their face. And that argument is simply incorrect. The jury did determine that the statements were not true on their face. Therefore, the very foundational predicate for this argument is just incorrect. And we can see that there is another argument that's dealing with the nuances of defamation law that also pulls in some insufficiency arguments. And the argument is that the jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to the law and unsupported by the facts. And as a subpoint, Heard argues there's no support for the conclusion that Ms. Heard initially made or published the headline. The newspaper added the headline, and Ms. Heard played no role in the authoring or publication of the headline statement. To really get into this, let's take a look at the actual statement that was sent out by Amber Heard. So as you can see with this, Amber Heard is essentially taking the tweet that had been done by the Washington Post, and she is retweeting it to her audience. And you can see here that a portion of the headline that discusses sexual abuse is mentioned, and that she is also providing some prefatory language to explain why this is important to her. So first and foremost, Heard is saying Depp never established that Ms. Heard made this statement. Their evidence was this is a headline that the newspaper chose. Amber had nothing to do with choosing it. They're saying, in fact, that Amber wasn't even aware of the headline until Johnny Depp sued her. She says even further that she did not notice it. So the problem with this, of course, these are sufficiency arguments. A jury's entitled to look at that and say, yeah, we don't believe a word you're saying. We think that you did notice the headline because you actually did tweet it. And we also think the fact that you're lying about it actually creates affirmative evidence that you're trying to cover your tracks because you know that you're wrong. And that actually acts as evidence to show that you knew all about it. But I think just from a really practical level, by Amber Heard retweeting that headline, she essentially adopted the statement as its own. And that's essentially what the law would consider a republication of the defamatory content, which is her next argument that she raises. And this, I believe, is a truly interesting and novel issue that Ms. Heard is raising. She's saying tweeting out a headline alone, like I sent, does not rise to the level of republication. This happens to be one area where I think the case law is somewhat favorable to her, potentially. The law is now grappling with how to deal with some of the new electronic content that's being distributed through social media. So if somebody says something and then perhaps someone retweets it, or it somehow appears, someone takes some action that causes that to appear in someone else's feed, is that considered republication? The Supreme Court of Virginia has not dealt with this issue, so it is a novel issue. But a federal court that sits in Virginia, the Western District of Virginia, dealt with whether a tweet in question rose to the level of a republication. And I want to take a look at that decision in Crosswhite versus Reuters News and Media. In that case, someone claimed that Reuters news agency committed defamation by tweeting something that implicated them in some pretty nefarious conduct that was happening at the time. In that situation, there was a tweet that stated, "Other great reporting on Falwell and Liberty U by @Aram Roston @JSCHNEY." And there was also a link to an article. And this was a situation where the court was dealing with whether this was a hyperlink in which there would not be an actual republication, or was something added to it where the writer essentially made it their own and added something to it, so it's a republication of a slightly modified but new statement. In this particular situation, the judge who was reviewing this said, if you actually look at what's listed here, there's defamation that arguably could have been attributed to this particular individual, that he was a boy toy of this one particular prominent person. But none of those statements, such as pool boy or anything along those lines, were actually mentioned in the tweet itself. And so therefore the court concluded this was a hyperlink that did not contain defamatory content, and therefore it was not defamatory. And the Fourth Circuit Court of Appeals, which is essentially the appellate level above the federal district court that was hearing this, determined that based on Virginia law, retweeting something does not constitute republication. So based on this particular ruling, if Amber Heard merely retweeted the statement in the headline that was issued by the Washington Post, she'd have an excellent argument that that did not constitute republication under prevailing defamation law. But after saying that, the Crosswhite court did walk that back a little bit to say, but this isn't going to always be the rule for every particular case. Now, the Virginia appellate courts are not going to be bound by the Crosswhite decision. They're going to be bound by decisions that have been rendered by the Supreme Court of Virginia over the years. The Crosswhite decision is very helpful authority, and it is going to provide some of the parameters that I think the appellate courts in Virginia are going to follow. I believe, though, that Amber Heard's situation is considerably different than the Crosswhite decision. In this particular situation, Amber Heard did retweet the actual language of the headline that discussed sexual abuse. She also indicated by providing this preface to say that this was essentially her story. And I think by doing that and then sending it out to her audience, which was probably considerably different than the Washington Post audience, she actually did commit a republication. So I do think that this particular case on this point is plowing some new legal ground in Virginia. I think that it's potentially Amber Heard's strongest argument, but I do think she's going to lose based on how this particular tweet was set up and sent out. Next, on page 31, Heard argues that Johnny Depp did not prove actual malice because she's essentially arguing that malice is a subjective standard, and she honestly believed that she was the victim of abuse, regardless of whether the jury believed her stories. It's a subjective standard, she's claiming. Subjective meaning if she believed in her head that she was the victim of abuse, then therefore, by law, she could not have acted maliciously. I did a video specifically dealing with the malice standard in this case. Take a look at that. It's not dealing with malice in terms of maliciousness. It's dealing with whether Amber Heard knew or basically disregarded whether the statements that she was making were false. I think that she just strains credulity too much with some of these arguments by saying, in my mind, I thought I was the victim of abuse. Some of these events, such as the bottle incident, they either happened or they didn't. And if they didn't happen, it doesn't matter what she believed happened. The jury determined that it did not happen. The jury determined that it was false, that it was a fabrication. They disregarded it. And so she can't come in now and claim that she believes something that is patently false. As far as the arguments on page 35 and 36 that Mr. Depp did not present sufficient evidence of defamation by innuendo, again, that's a sufficiency argument. That's going to lose. It's clear from the verdicts that the jury determined that Amber Heard intended the statements that she made in the op-ed to be about Johnny Depp. So this brings us to the last point, which is on page 40 of the brief, that says that the court should conduct an investigation of juror number 15 and whether jury service was proper and due process was protected. Heard is arguing that there was one particular juror, juror 15, who was seated on the jury. The court noted that the individual was born in 1945. What's interesting, though, is the next statement says, juror 15, however, was clearly born later than 1945. Publicly available information demonstrates that he appears to have been born in 1970. Basically, the defendant is pointing out, Judge, this was obvious to everyone that this juror was actually 25 years younger. And so the big problem that you can see on its face is that Amber Heard is saying that this is an issue that was readily apparent to everyone. That's something that Amber Heard had the ability to see at the time. Amber Heard had the ability to deal with it. It was obvious. She had an opportunity to deal with it. She's herself admitting that she knew or should have known about it and that she was in a position to deal with it at the time. So we get these documents, and then we have an opportunity to go and meet with the jurors and actually ask them questions as part of jury selection, or what's called voir dire. And with this, we actually have this information, and we may ask them questions such as, juror number 2, I see that you are 62 years old and that you are happily retired. How's that going for you? Where did you used to work before you were retired? What did you do there? And we have an opportunity to ask those types of questions. If it's obvious that something is off, like Heard's team is saying, about someone's age, that's something to ask the juror about at that time. And just like everything else in Virginia law, if there's a mistake or an error that the court's making, and you don't call that out, and you don't make an objection, you waive that. You lose the right to challenge that on appeal if you don't raise the issue at a time and at a place where the judge has an opportunity to fix it. Where Heard's team would have a much better argument would be if they said, or who claimed to be 25 years older than they actually were, was not actually retired, and is actually an executive with the Washington Post. That's a bombshell. That's something we're like, whoa, whoa, whoa. This is someone who has a dog in this proverbial fight. This is someone who is involved, who has knowledge about this particular instance. It is the Washington Post conduct that is being called into question as far as what Amber Heard did and used them to do. That's the sort of thing where you say, that is a materially important thing that we should have known, that was withheld from us, that prevented us from having a fair trial. But I don't think that this is a John Grisham runaway jury type situation where someone was planted on the jury and they were there to disrupt the deliberations and to drive a verdict for Johnny Depp. There's just not going to be that type of a situation. Hey everyone, after I shot my video, but before I had an opportunity to publish it, I learned that yesterday Amber Heard's team filed a new supplemental brief in support of their motion to set aside the verdict. And in it, they're really providing some more information about this juror issue. And they're saying that basically it looks like the gentleman who appeared and served on the jury lived at the same house and has the same name with the gentleman who was actually called and summoned to jury service. Heard's team is saying, well, the wrong person showed up for jury duty. It was perhaps the son when it should have been the father. But I don't think that this really changes anything for three reasons. First, the law says that you're entitled to have a jury of your peers. And basically, Virginia law says that that would be a jury of fellow citizens. So if this person was an actual citizen of the state of Virginia, then I don't think it really matters. Second, the Constitution does provide everyone with the right to have a trial by jury of their citizens, but it doesn't give a constitutional right on how those citizens are selected by the court. I don't think that there would have been a constitutional violation if the court went and selected 30 individuals that it found walking on the street before this trial and then made those potential jurors available for the jury selection process. So long as they are citizens, then that is something that it would satisfy any constitutional issues that could arise. Now, granted, there is a law that says how jurors will be selected, but that's just to prevent having an arbitrary way of doing it where you do go out on the streets to select folks. And I don't think it matters at the end of the day exactly how the jurors are selected, so long as it is a cross-section of folks in the community who are actually citizens of the Commonwealth of Virginia. Third and finally, take a look at Virginia law. Here's a provision in question 8.01-352, where it actually says that there needs to be some sort of a showing that there's prejudice. And without that showing, there's not going to be a basis for a mistrial or a new trial or anything along those lines. So even though ultimately this is a headline-grabbing statement that's being made by Heard's team, I think it probably doesn't go anywhere because she can't show that she suffered any prejudice as a result of this. Like the example I gave, if she could show perhaps that this individual was employed by the Washington Post and that was something that was withheld in addition to this issue about his identity, then that could be problematic and that could be something that the court would really need to take a hard look at. So in sum, I don't think that this motion is going to go anywhere with the trial judge. I don't think that she's going to disrupt the 21-day running of her order. She may enter a new order that basically denies everything that is requested herein. But I think that these issues are going to be raised on appeal. So let me know if you have any questions or comments. Leave them below. I'll try to address them. But thanks for watching. If you haven't done so already, please consider giving me a like and a subscribe. I hope this is helpful, and please stay tuned for more videos. Thanks.